Hello, everyone. Welcome back to day two of CAWA Malaysia. Today, we have a very exciting speaker event, Can Copyright and NFTs with lawyer Lim Kuan. So Lim Kuan is a practicing lawyer in Malaysia, focusing on intellectual property and commercial disputes. He is a partner in Ming and Partners, a multidisciplinary commercial law firm based in Kuala Lumpur. So now I will hand over the floor or the space to Lim Kuan.
All right. Thank you so much. Thank you so much, Leila, for the introduction. And of course, before I start off, I would like to express my gratitude. Thank you so much for Munira and Faris for inviting me to this CAWA Malaysia event. It is my privilege to be here to be sharing a little bit of tips and some more about copyright and NFTs in Malaysia. So let's get our presentation started. So do let me know if you are unable to see my screen clearly. Can everyone see the screen clearly? Okay, I've launched the presentation. Can you see it clearly now? No. Yeah, let me share the screen. Just hold on a while. Yeah, I've shared it now. Can you see it? Just hold on a while. Let me reshare the screen. I'm so sorry for this. Yeah, let's make it reshare it. Okay.
For the this to be resolved. Ling Kuan, thank you for helping us out to clear this NFT copyright thing.
Yeah, thank you so much.
We have some discussion on this matter.
Yeah. So is it on now? It's still a white screen. Okay. Just now our testing was all right. Huh? Wait a minute. It's okay. I'll try and share this. Okay. How about hold on a while.
Okay.
Yeah. How about this? How about this? Can everyone see the presentation?
No. You open your PowerPoint.
Yep.
Sorry for the technical problem.
Yeah, hopefully. Okay, I've reshared it. Can it work now? Still no. How about it? Is it working? Can I start now? Yeah, okay. All right, so sorry everyone for this unexpected technical glitch that happened with it. So before I start, let me have a quick introduction of myself again. My name is Kuan. I'm a practicing lawyer in Malaysia. All right, so before that, let us go through the usual boring stuff in a presentation for a legal presentation. So first of all, let us set down the house rules and everything. So this presentation is provided for a general information purposes only, and of course it is meant to be does not constitute as a legal advice. So we of course will require you not to please do not reproduce or record this presentation without prior consent. And of course, my firm, Ming and Partners, will retain the copyright in relation to this presentation. Right. So, first of all, today we had broken down today's topic, copyright and NFTs, into 9 bite-sized topics here. So, we have numbered our slides accordingly, and therefore, once we go through every section by section, you will find out more about copyright law and NFTs as well as we go through it. So, and of course, this is also an indication that the more the number proceed towards number 9, the quicker this presentation is going to end. Understand, legal presentations sometimes may be taxing, may be technical, and may be boring. So this is all for your benefit, all right? So right after this, we'll start off. So today we go off with our agenda. We have 9 topics here. We start off with copyright. We start off with what works can be copyrighted. Then we focus on artistic work. After that, we go on to the offense and defense of a copyright infringement action. After that, we'll go for remedies, and we will also examine NFTs and the legal issues surrounding it in Malaysia. Okay, so let's go to what is copyright. Copyright, it is more than a right. It is actually a bundle of rights being granted to the author or the copyright owner. So it is an exclusive right to control your creative works created by authors, copyright owners, and so on for a limited period of time. It is governed under the Copyright Act 1987. As I said, it's a bundle of rights. You can reproduce it, which is make copies of it, communicate it to the public, tell the public about it, show to the public, sell it, and even rent it. Of course, under the Malaysian Governing Authority, MyIPO, which is the Intellectual Property Corporation of Malaysia, you can file a voluntary notification to prove the ownership of the work that you have created as a prima facie proof. So this means that on the surface itself, once you file a voluntary notification with MyIPO, you are able to prove your ownership prima facie. So what can be copyrighted? Essentially, there are 7 categories of works that can be copyrighted. There are literary works. Literary works would include books or even computer programs. Musical works such as songs, artistic works, we'll zoom in a little bit more on this since today's festival is an art festival. We also have films, including video clips and also movies and so on, sound recordings, broadcasts, and derivative work. So what are derivative works? This would include translations or even compilation of works of a combination of the first 6 categories that we have mentioned above. So all these 7 categories of work can actually be copyrighted under the Malaysian Copyright Act itself. So before we go further, since today it is a Crypto Art Week Asia Malaysia edition, it is I believe that today's event we have more artists around here in this hall or in this space itself. So I think we should zoom in a little bit more on what are artistic works. So artistic works, there are 3 main categories of artistic work. First is either a graphic work, photograph, sculpture, collage, and so on. Pay attention to the word of irrespective of artistic quality. The second category is architecture. The third category is artistic craftsmanship. So let's go back to the graphic work. So this would include many things: paintings, photographs, art created whether in print, in canvas, digitally, or otherwise. So as long as the graphic work, it is an artistic work. However, the words irrespective of artistic quality can be discussed a little bit further. So fun fact, in fact, engineering drawing, technical drawing in relating to building something, in relating to creating a creating a meter, creating a product, and so on, can also be categorized as artistic work. That's why the word irrespective of artistic quality, as long as it is something that is reproduced on a paper or on digital canvas, and so on, that is satisfies the graphic work and photograph and so on. So this is the interesting part about artistic work, work that can be eligible for copyright protection. So who would own the copyright? Here comes a very important question. Artists had spent hours and endless of hours and efforts to try and create the work that they now do have. So by default, it is the artist who creates the work owns the copyright itself. In fact, the Copyright Act in Malaysia states that the artist will always be the first copyright owner. However, there are only 3 exceptions that the artist will not own the copyright. So artists, please beware about this part. There are 3 exceptions that you may lose your copyright over your artwork itself. So the first exception is if you sell your artwork by a deed of assignment, where you have assigned off the copyright to the buyer or the collector. This is the first exception itself. The second exception, commission. If the work is being commissioned, then you may not be able to, if the work is being commissioned by a client or a buyer, then you may not be able to own the copyright anymore. Why? Because this work is particularly created by a payment made by the NFT, made by the buyer or made by the collector itself. So here's an example. So if a buyer suddenly comes to you today and tells you that he's going to make payment of money to you and asks you to create a work, and therefore this work can be a commission work and you may not own the copyright anymore. And finally, the third exception is if this particular work is created under employment. Say, for example, you may be a part-time artist and you have a day job working Monday to Friday. All right. So, however, during your weekends, you like to create your art and so on. However, it is important to note that in most employment contracts, there will always have this particular clause that states that if any intellectual property created during the employment will be owned by the employer itself. So this is a very common clause that you may find in an employment agreement. So of course, this is nothing wrong about it because that is the law. However, it is important for you, before you sign an employment contract, if you are a part-time artist, before you sign an employment contract, remember to check clearly on this particular terms that governs the IP right of yourself when you create an IP work, when you create an artistic work. So one of the few ways that you can do about it is you can either create, if you are a part-time artist, you can either create your artworks after work hours and during weekends. However, if you do it during your work hours and during your employment itself, you may lose the copyright over your artwork that you have created. So another example is probably like Disney. Disney could have hired a lot of artists to create artistic works and creative works for them. However, these artists will not own the copyright towards it. Disney, in the end, as the employer, would own the copyright over these artworks. So how long would copyright last? Essentially, all the artists, it will last the lifetime of yourself plus another 50 years after the death. So this means that your son, your cucu-cicit, okay, they are able to enjoy the benefits of the artwork that you have created. So the personal representative after your death would actually swap the mantle as the copyright owner to exercise all the rights a copyright owner would have. So here we go to the next page. So we have examined what are artistic works already. Let's have a look about what are the rights of a copyright owner. Essentially, there are three main pillars. The first pillar is a legal pillar, the right to enter contracts, which governs your licenses and royalties as well. Because under the legal scheme in Malaysia, you have to understand that in order for you to enter into a contract, you must have the contracting capacity, or some jargon call it locus standi. All right. So without a contracting capacity, you are unable to enter into a contract. So only a copyright owner can enter into contract for licenses, royalties, and so on. Okay. It is also important to remember that an artist may not be the copyright owner. Okay, I'll repeat again. An artist may not be the copyright owner. How would you not be a copyright owner? It falls under, again, the three exceptions that I had mentioned earlier. One, sale by way of deed of assignment. Secondly, you do it under an employment. Thirdly, the work is being commissioned. Okay, so let's get back to your legal rights here. Besides the right to enter into contracts, you also have the right to sue for copyright infringement. So as I mentioned earlier, locus standi, or your capacity, is incredibly important to sustain a sustainable lawsuit in court. If you are not the copyright owner, court will not hesitate to strike out your suit in court because you do not even have the locus standi or the capacity to bring the lawsuit in court. So it's very important for you to ascertain whether are you the copyright owner or not. If not, your lawsuit will be struck out in the court of law. And this has happened many times in the Malaysian courts already. So that's the first pillar of your legal right. What about the second pillar would be your economic right. So essentially the economic rights are the bundle of rights that I've mentioned earlier. You can reproduce, make copies of your work, distribute the copies, sell it, rent it, and essentially you have the right to derive financial rewards due to all the hard work, effort that you have spent into creating that particular art piece. Finally, we talk about moral rights here. Moral rights is something more personal towards the artist or the author in general. There are two main moral rights here. One, and I would say this, that moral rights will follow you forever until the copyright ends. So your death plus 50 years your death plus 50 years, the moral rights will follow you. So one of the moral rights, the first moral right is a right of paternity. What does it mean? It means that anytime anyone uses the piece of work that is created by you, they have to identify, or in our usual commercial sense, we call it credit. Give credit to someone else. All right, give credit to the people that have created and the artists that have created the artwork. So that is the moral right of every author and every artist out there. The second right is a right of integrity. So this essentially prevents users of your artwork to distort it, mutilate it, or modify it not according to your the way that you envisage or the way that you vision your work to be. So I'll give you an example. Today, even if you sell out an artwork to someone else, okay, to an NFT buyer or an NFT collector, or even a normal art collector, all right, it doesn't mean that this art collector or art buyer can scribble, can destroy, can mutilate, can modify your particular artwork, because moral rights are personal in nature. Even though you may not be the copyright owner anymore, you still own a certain moral right of integrity to prevent users from distorting or mutilating your particular work itself. Of course, if you have an issue of a buyer that has destroyed or even made substantial modifications towards your work, you will have a legal cause of action against this particular art buyer. So these are your rights as the copyright owners of artists. So subsequently, let's go on to a copyright infringement action. Here we talk about the offense and defense, the attack and the defense of a copyright infringement action. So as I mentioned earlier, the locus standi is incredibly important, or your capacity. So who can sue for copyright infringement action? The answer is only the copyright owner, not even the author. All right. So it's important that you are the copyright owner. So who can be sued? Any person or corporate that uses any copyrighted works without consent from the copyright owner would commit an act of infringement. So I'll give you some examples of act of infringement, and it may surprise you how easy it is to infringe someone's copyright. So one example is make copies of work in any material form. Either you Control-C, Control-V, that could be one way of act of infringement already, in print or digitally. Secondly, if you sell or rent the infringing copy, or distribute infringing copies, or possess infringing copies. One of the very classic examples are pirated CDs or pirated DVDs. So these are the sale or rent of infringing copies of a disc that actually infringes the copyright owners, the firm owners' copyright itself. So these are all acts of infringement. Okay. So when we talk about copyright infringement action, it is actually focused on the civil action. However, your rights are not limited only to a civil remedy itself. So for a civil action, let's go through the civil action first, which is an action between private parties in Malaysia. So private entities can sue each other if they have a reasonable and proper course of action. So a civil action, essentially you start off by issuing a formal demand to request the infringer to cease and desist. Next, if they decline to do so, you bring a civil action against the infringer in Malaysian court. That's the civil action. As for the criminal action, you can lodge a complaint with the Enforcement Division of Ministry of Domestic Trade and Consumer Affairs, KPDN, HEP. The Enforcement Division can then conduct raids and seize the offending items. So these are the rights that you may have, the infringement action. So what are the remedies that essentially you may get out of taking action and enforcing your rights as a copyright owner? For civil remedies, you have damages. Your damages means the compensation amount that you are supposed to be paid in the event that your artwork has been infringed. Okay, you can get an injunction as well. Injunction, there are many types of it. One of it is a permanent injunction that will prohibit the infringer forever from infringing your piece of artwork or your copyright work. So in the event the infringer tries to break the injunction order, the infringer can be liable for contempt of court, which means that he can be sent to jail for breaching the injunction order. That is a permanent injunction that may be in the favor of the artist and the copyright owner. Of course, there's also accounts of profit as well. So actually, it's not much money to be made if you're trying to infringe other people's other artists or other authors' works, because the court can actually assess an account of profits of all the money you have earned by infringing other people's or other authors' works, and then order for the necessary portion to be paid back to the copyright owner for the accounts of profit itself. Of course, there are also additional damages, statutory damages and exemplary damages, different heads of damages that you may claim under a civil action. As for a criminal remedy, essentially it is the state, it is the government of Malaysia, it is the KPDN HCP that is the one that is taking action. So you could be liable for fine from 2,000 to 20,000 per copy. Okay, please be reminded it's per copy. So essentially, this amount can grow exponentially if you have 100 pieces of pirated CDs laying around in your home, okay, or 100 pieces of artwork that you copied from elsewhere laying at the place that you were being seized and arrested. Okay. As for a subsequent and continuing offense, the fine may be raised to 4,000 to 40,000 per copy. As for imprisonment, it will be not exceeding 20 years or both. So these are the remedies for copyright infringement. Subsequently, we talk about the attack of copyright, the offense of copyright infringement. Now we can discuss a bit about the defense. How actually do you defend against a copyright infringement action? So there are several defenses under the Copyright Act in Malaysia. So we examine a few important ones. First, you have a fair dealing. Whether is it for commercial use or non-commercial use, whether it's a private use or a commercial use. Most of the time, if it's a commercial use, you will not likely succeed under the defense of fair dealing. Okay. As for parody, you can also rely on the defense of parody as well. You may also rely on an incidental inclusion of a work. So say, for example, today we went to the Mozilla Hub and took a picture of your friend. However, inside the picture, it has accidentally featured a work of an artist inside it. And that could be a copyright infringement. However, you may rely on the defense of an incidental inclusion of the work itself in an artistic work. So that would not be an issue because you may have a defense to it. Of course, educational purposes, judicial proceedings, and also press reporting are all defenses to copyright infringement itself. Okay, so after we had a slightly basic understanding about what are copyrights in Malaysia, what are the laws governing copyright in Malaysia, let's examine a little bit more what is NFT. So I believe that many people in this space and in this call are probably NFT experts that you have a lot more experience in it. However, for the benefit of everyone, I'll just quickly go through the explanation and definition of the NFT itself. So NFT, it means a non-fungible token. Essentially, it is also a digital token issued on the blockchain, which certifies a particular digital asset to be unique and not interchangeable. All right. So here are the NFTs and art. Here is the correlation between NFTs and art. I believe NFTs have actually existed quite some time ago. However, it has gained prominence and gained popularity, especially in the art industry and the art world, that since early 2021 this year. So there are many ways of how artists can participate in NFT marketplaces and sell their art on NFT marketplaces. So here is a general and one of the simplest way available for artists on how to sell it. So we start off by the first process. First, the artist can create or mint artistic works on NFT marketplaces. So essentially, these are the terms used for NFT marketplaces. To mint an artistic work, you have to be to mint an artistic work, you have to be paying ETH or paying a certain sum for gas fees in order for you to mint that particular artistic work. So after that, an NFT will then be issued with a digital certificate to authenticate that particular version of artistic work. After that, the buyers may purchase NFTs and NFT marketplaces, and it is important to note that the NFT buyer, what they are purchasing is the ownership of the NFT and not the art nor copyright of the art itself. So it's very important to remember that. So I'll repeat again that NFT buyers, they do not own the copyright in the NFT itself unless agreed otherwise by the artist. So, of course, you may wonder at this point of time, how do artists protect themselves? And actually, what are actually the NFT buyers buying? So we'll examine that a little bit more further. Hold on a while. All right. So is everyone okay so far? I continue with it. All right. So yeah, we hope that there's no technical glitch happening. They're just double checking. Right. Thank you so much. Thank you so much. I was just checking on whether is the stream going fine. All right. So I'll just continue with this part, that how artists or creators can actually protect their copyright in an NFT sale. So we examine some examples all around the world. So NFT marketplaces such as OpenSea, Super Rare, even NBA Top Shot, or even Mike Shinoda's NFTs have terms of use governing the use of NFT. So they will state clearly whether the use of NFT is for personal or commercial users. And it also governs the sales and purchase of the NFT, usually only allowing them to trade and sell the NFT on the similar platform or otherwise. And also, it also governs the copyright of the artist or the creator themselves. So let's examine some examples. First of all, we look at NBA Top Shot itself. NBA Top Shot's terms of use clearly states that the NFT buyers, they do not have the right to reproduce, distribute, or commercialize the NFT without prior consent. So here is an example of a LeBron James dunk, which is issued in series of in 59 editions. So this is the number 3 edition, which is currently owned by Ding-a-ling. So this particular edition is it's unique in the whole world, and of course, it is also licensed by NBA as well. So this clearly states that the person that currently owns this NFT, which is this third version out of 59 versions, will not have the right to commercialize this particular highlight of collection itself. So the NFT buyer, what they have is a private collection that they can have it whenever they want to use it. Of course, it is up to the NFT buyer to sell it out again, to resell it for a higher value when LeBron James one day retires or one day have his jersey hang out on Raptors. So those are the situations governed under the terms of use by NBA Top Shot. So there's another example here. Let's talk about Linkin Park's lead vocalist, Mike Shinoda's NFT term. So Mike Shinoda had also been quite active in selling his NFTs on the market itself. So one of it is his song Happy Endings. He released a 75-second of the song and made it into a NFT itself. He only sold five versions of it. Please correct me if I'm wrong, if the number is not correct, right? So for Mike Shinoda, he also clearly states his NFT terms of use at his website. What does it grant you as an NFT buyer? He grants the NFT buyer a limited, personal, non-commercial use and resale rights in the NFT, but Mike Shinoda will retain all the copyright of his work, including the songs, the artwork that he had created. So these are the ways that artists can protect the copyright of themselves, because essentially NFT buyers are buying NFT, not the art, not the copyright of the art itself. So after we understand how do artists all around the world they protect themselves by way of terms of use, essentially the model right now is a licensing model. It is a private license granted to the NFT buyer for them to have it for their personal enjoyment and non-commercial use and so on. Of course, if they want to sell their particular collection, that is also a private use for them as well, as long as they do not commercialize it and make multiple copies of it and then sell it out again in the whole world. However, NFTs, you are unable to make multiple copies of it because it's unique and not interchangeable, but they are also not allowed to use the digital artwork itself to make multiple copies around it and infringe their copyright owner's right. So after all that, we examine the three main legal issues that we may come across when you're dealing with the NFT. So the first legal issue that most NFT artists and NFT buyers may dealt with is the fraud or misrepresentation as a copyright owner. So an NFT creator in an NFT marketplace may not be the original author or the copyright owner. So how does it work? So essentially, because in this internet world, we believe that everything is easily copied around and easily reproduced. So today, they may go into a virtual art gallery, take a picture of the art being listed there, and then go to one of the NFT platforms to mint it and list it and sell it as if he is the author of the particular artwork itself. So that could be a fraud. If you are an NFT buyer, there could be fraud when you are buying artwork that the NFT creator that do not really own the copyright towards it. So that is an issue right there. You may end up buying counterfeit art and eventually suffer losses on your investment. Of course, there's also another issue that you remember, I believe, is how easy for you to infringe someone's copyright as long as you possess an infringing copy of it. You may also be liable for copyright infringement action in the event the copyright owner wants to take an action against you because you have purchased a counterfeit art and currently still store it within your ledger, currently store it within your possession of that particular infringing art. So that is the first legal issue that we may foresee. So the second legal issue is, of course, about the ownership of intellectual property rights. The copyright of NFT is always retained by the artist or the creator unless agreed otherwise in writing under the law. So in Malaysian law, it is extremely clear that without an agreement in writing, without assigning the copyright away from the artist or the author, the artist and author will always have the copyright retained by them. So without the artist's prior consent, the NFT buyer cannot display, copy, or uses the artistic work for any commercial purposes. Otherwise, NFT buyers may also be liable for copyright infringement legal action. So that is the second legal issue that we foresee that it may happen. And of course, let's move on to the last legal issue right here, that it may happen towards an NFT sale and NFT issues. So the sale of NFTs may attract income tax itself. Of course, currently in the Malaysian regime itself, it is uncertain whether the resale of NFTs by NFTs buyers attract income tax. So you are always advised, if you are an NFT buyer, to document your profit and loss regarding the trading of NFTs. However, I also would like to inform, I also would like to highlight the fact that whether the sale of NFTs is deemed as a taxable income, it will depend on many factors. A few factors, one of it is whether are you day trading? Are you day trading NFTs as if it's your main income or it contributes to the main income of yourself? So if it is, and also it depends on the frequency on how do you trade NFTs and how do you buy and sell NFTs. Say for example, today you establish a company or yourself as a sole proprietor, purely in the business of trading and selling NFTs, you may have a problem in the future because the taxman may come knocking on your door and ask you, why are you not paying your taxes? Because this may attract income tax. Of course, again, we have to clarify that there's no law in Malaysia governing NFTs at the moment. We are all in uncharted territories right now. All right, so I'll right now move on to the conclusion. So the conclusion is that, as I mentioned earlier, for NFT particularly, it is uncharted waters in Malaysia right now, although there's an interesting development in Malaysia regarding cryptocurrency. So I'd like to highlight this case study to you. So Malaysian court actually recognized Bitcoin as a security and also a commodity under the Contracts Act of 1950. In fact, some interested parties have brought this case to court, fight it out in court, appealed in court, and won in the appeal court as well. So essentially, right now, Malaysian courts recognize Bitcoin, cryptocurrency, as a security and a commodity. So I'll just go a bit further on what does this case talks about. This case is the Robert Ong against Luno Limited and another. I believe the crypto enthusiasts and crypto experts here would know that Luno is definitely one of the recognized market operators in Malaysia right now for cryptocurrency. So in this case, Luno accidentally transferred a certain amount of Bitcoin to Robert. Robert doesn't want to return this amount of Bitcoin to Luno. Luno is unhappy. Luno sues Robert in court and asks Robert to return this Bitcoin to Luno himself. Therefore, the court is being posed this question: what is Robert returning? What is Bitcoin? How do you recognize Bitcoin? So in essence, the court has recognized Bitcoin as a security and also a commodity, or specifically under the Act itself, it's anything under Section 73 of the Contract Act that allows a person that has mistakenly took someone else's property to restore the aggrieved party back to the original position, return the Bitcoin back to Luno. So that is the current Malaysian position. But it is important to distinguish between Bitcoin is a security, Bitcoin is a commodity, that is correct, but Bitcoin is not a legal tender in Malaysia. Bitcoin, you cannot go to a car workshop, car sales center and say, I want to buy a Tesla using Bitcoin. No, you can't do that in Malaysia. It's not recognized as a legal tender yet in Malaysia. So you cannot also go to a developer's office and say, I want to buy this condominium using Bitcoin or Ethereum. So you can't do that because it's not a legal tender. But if there's a case of a mistakenly transfer or mistakenly you part away with your Bitcoin, you can request for it to be returned. These are the development of the laws in Malaysia at the moment. Of course, for NFT, there's no laws in Malaysia, as we have mentioned. It is advisable for NFT stakeholders to consult legal advice to protect your own rights itself. Okay. So finally, I would like to end my presentation. I would like to thank everyone for listening to me for the past 30 minutes. I, of course, hope that this very brief introduction and the copyright basics, introducing you the basics of copyright will help you in understanding more, regardless you are an artist, you are an author, you are a creator, you are a NFT buyer, you are an NFT platform, you are an NFT platform operator, you are an NFT collector. I hope that this copyright and NFT presentation will help you. So finally, I would like to end this presentation. Feel free to follow us on our public social media pages at Facebook, Ming and Partners, LinkedIn, Ming and Partners, and also Instagram, Ming Partners. You can also visit our website, and here is my email address if you have any further questions for me. So I believe I'll end this presentation. Thank you very much for listening, and let's move on to the live Q&A session. Thank you very much. Okay. Okay, so right now will be the Q&A session, right? Hi, Faris. Hi, Moon. Just checking with you. Okay, so I supposed to answer it in I'll just read out the question and then I answer it. Oh, okay, you want me to Oh, okay, sure. I'm fine anyway. Okay, all right. So let me try and answer this question because I'm not sure what artwork that you are referring to, because if you are saying that it's a physical artwork, once you have sold it out already, you do not have the copy anymore. But say for example, if you're talking about digital artworks, so in this case itself, for digital artwork, yes, you still can exhibit it in a public exhibition even though you have sold it out to the collector, because it depends on what is the sale terms that governs you and the art collector themselves. So say for example, if the terms of use has a particular clause called a deed of assignment, or is it being crafted in the deed of assignment, and you have assigned away your copyright to that art buyer, no, you do not control the copyright anymore. But if there's no clear terms regarding that, there's no deed of assignment that assigns away your copyright, you are the author and you still retain the copyright to your particular artwork itself. So the answer is, of course, it always depends on what is the terms of sale governing you and your art buyer themselves. All right. Okay. I think you may be referring to the decentralized automated organization. So I'm not sure about it because I'm not sure about it whether it's it, but I'll try and answer this question. So if you're referring to decentralized automated organization, so essentially these are from my very brief understanding about it, because I can tell you for sure that in Malaysia, no company is using DAOs, or no organization are using DAOs at the moment. So Malaysian, in any corporate, in any organization, be it a sole proprietorship, be it a partnership, LLP, limited liability partnership, Sendirian Berhad, or even a Berhad company, they all are governed under the Companies Act or the relevant act itself, which governs the way the company is being operated, how the votes are being counted, how a company's decision is being made, and in essence, the one of the most important consideration is always whether are the directors or are the shareholders acting in the best interest of the company themselves. So if I understand it correctly, DAOs are more like a programmable organization that you are able to vote, you are able to make decisions based on the holdings of the tokens that you have in that particular company or particular organization itself. So I can tell you that Malaysia, there's no one doing it yet at the moment, or at the very least, it will not be it's not recognized at the moment.
For the second question, the third one, what is the legal framework that governs crypto in Malaysia, if any?
The legal framework. All right. So essentially in Malaysia, I think there are just a few acts that are governing cryptocurrency right now. So they are all mainly under the Capital Market and Services Act. There's also in 2019 itself, there's a particular order. We usually call it the 2019 order that governs cryptocurrency in Malaysia. So there are only a few recognized cryptocurrency in Malaysia at the moment, which is Bitcoin, Ether, Lite, and Ripple. And of course, in Malaysia, there's also a very limited recognized market operators only in Malaysia. There are only three. One of it is Luno, Synergy, and Tokenize. So these are the current framework in Malaysia governing cryptocurrency at the moment. There are no laws, there are no acts yet governing it. It is currently it is a regulation. There is a 2019 order that governs this itself. And of course, it is also now being treated as a securities, and the main governing authority over cryptocurrency is Securities Commission, SC in Malaysia. Yeah, hope that answered the question.
Okay, and then the fourth question. If someone, let's call them the NFT exploiter, used a vulnerability in the smart contract of a marketplace to collect more editions of the NFT than they purchased, what laws have they broken? What is the legal jurisdiction that applies? What if they resold those same editions? What if they made a little money, less than $100 maybe? And who should press charges, the artist or the marketplace? And who would investigate such a thing? Do you know of any precedents?
All right. Thanks, Faris, for reading it out. It's a long question. All right. Currently, there are no precedents in Malaysia that governs particularly NFT. So let's say, for example, in this scenario itself, there are multiple causes of action that may arise. So first of all, let's talk about the artist. Okay. So if someone actually infringes your art, you are always have a legal cause of action for copyright infringement. Definitely, you have that. Secondly, this particular NFT exploiter had also used a vulnerability in a smart contract of the marketplaces itself. In essence, this NFT exploiter could have exploited or could have infringed the terms of use of the marketplace itself. The marketplace also has a cause of action for improper usage of the marketplace itself and sue this particular NFT exploiter for a damages or so on. All right. Then, of course, if you want to make any complaints at the moment, I do not think that there are currently criminal actions available for you. However, there are always civil actions and civil remedies that are available for artists and also for the marketplaces at the moment. Yeah.
All right, thank you. Okay. The next question. The elephant of all elephants, are cryptocurrency gains taxable?
Okay. Cryptocurrency gains are taxable or not. This is currently untested in the market. In essence, as I mentioned earlier, if you are day trading, if you use it as a main income source, you may be taxable by the tax authority. So therefore, it is always advisable. I can't tell you whether it will be taxed or not at the moment. There's no precedent yet. However, I can tell you for sure that you must prepare and collate all your documentation in advance to document your profit and losses for cryptocurrency.
Okay. I hope that clears. If
I hope that helps. Yeah.
if someone use my art and mint as NFT and sell in crypto, can it be brought to court of law? Is the court recognizing NFT as the transactions in blockchain?
Yep. So I'll try and answer this question. I already touched about it in the presentation a bit, so I'll just quickly answer this. So essentially, if someone infringes your art, you, as the copyright owner, you can sue them for copyright infringement. There's no law, no precedent in Malaysia that recognizes NFT yet. However, when there's a wrong being committed on you as the copyright owner, you have a reasonable cause of action to sue to get back the damages that you deserve for the infringing action itself. So I hope that answered the question.
I would like to add to this because nowadays we are doing this like the whole world. Like let's say the artist that that use my art is a foreigner, like someone from other countries. Like
Yeah.
How do we like engage this problem? How do we bring it? Which court should we bring it to? because the guy is not a Malaysian but someone else.
Correct. I understand that. So yeah, thanks for the question. It's a very good question indeed, because this is essentially NFT marketplaces are global in its scale. So most of the time, the best way is to go to the country or the jurisdiction where the perpetrator is located at, if you are able to locate where the perpetrator is. So that is one of the way of doing it.
Okay. All right. Next one. Can you sell a fan art as NFT?
Yeah. Fan art as NFT depends whether you infringe the copyright of the original copyright owners, because it's a fan art. However, of course, if it's for fair use purposes, all right, and somehow you have gotten the consent of the copyright owner, that shouldn't be a huge problem if you are trying to sell it as an NFT. But this will depend on the copyright owner's consent.
Okay, if the art pieces are made with a grant, especially given by institution, can only be published after their approval, will the artworks copyrights be mine or theirs? Am I able to mint them as NFTs? Like for example, we have the Cendana grant. Like I think many artists in Malaysia have the Cendana grant, so maybe they are talking about this.
Yeah, that's right. That's a very pertinent and a very direct question. Yeah. So in essence, I have to say that you have to look back in the terms of the grant itself. So whether this grant itself governs the intellectual property rights or not of the artist by the funder giving you the grant to commission the work itself. All right. So it's a different story. A grant and a commission is a different story. A grant is probably an assistance, or a grant itself that is a one-off for you to help in terms of creation of this particular artwork. All right. But if it's a commission, if it's being treated as a commission, you will not own the copyright of the artwork itself. All right. So I'll repeat again. If it's treated as a commission, if the wordings of the grant or the terms of use are unclear, the contract is unclear, it can be treated as a commission, and you may not own the copyright of the work itself. So it's important to always look back at the contract itself.
So basically, read your contracts.
Yeah, it's very important. Yeah. I know it's a boring legal stuff, but yeah, it's important. It's important.
Okay, so back to like you say about the car dealer. That this is my question. What if the car dealer or any shop accepts cryptocurrency? Like so because you say you cannot buy a car with cryptocurrency, but what if the car dealer accepts?
All right, I understand that. Yeah. So say for example, today you went to one of the car dealers. You say, I want to buy this car ABC, and they say, okay, I accept Bitcoin. So you pay me Bitcoin, I give you this car, right? Yeah. Okay. So this question, it revolves. Yeah. Is that it?
Is it like I mean, does the purchase legit or not?
Yeah, that is the question. I think that is the right question you are asking as well. Such a purchase may be deemed as illegal in Malaysia, and what is the effect? All right. Say that if this transaction is being deemed as illegal, the whole contract can be void. Okay. So the whole sale of the car can be void, and in essence, parties have to be restitute to their original position, which means that person will not own the car anymore, and the buyer must return back the Bitcoin as well. So basically, an illegal contract cannot be enforced in the court of law. The contract will be voided.
Okay, thank you.
Yeah.
Okay. Some say selling NFT is like selling securities like Bitcoin. What are your thoughts? I think you already answered this.
Yeah.
Do we need to apply copyright of our artwork before we sell it as NFT?
Yeah, I'll give you this. An artist, your copyright is by default. As long you create it, your copyright is yours. That's why the Copyright Act clearly states an artist will always be the first copyright owner. So of course it's important. Remember to put your signages, put your name, put your monograms, put your initials and everything that can identify the particular artwork is yours. So then you will be the copyright owner, and you don't need to apply for anything particularly. But of course, under the current Malaysian law regime, more and more, from my experience, more and more software programmer, more and more artists, more and more copyright owners, they are using this voluntary notification, which is under the IPO, Intellectual Property Corporation of Malaysia, the governing authority of IP in Malaysia, to register their copyright so that they can be afforded a prima facie level of ownership of the copyright itself. Yeah, so this is one of the ways if you want it.
Maybe about this, I would like to add some. I just read a news. I think it was maybe 2-3 days ago, but it's in the US. So this one celebrity, there's a paparazzi taking her photo, and then she took that photo and then uploaded in her Instagram, and then she was sued for it by the paparazzi because even though she's the subject of the photograph, and then it was taken by the paparazzi, and then she uploaded the photo in the Instagram, and then the paparazzi managed to sue her. So what do you think about this?
Yeah, I'll comment a bit about this case, right? Okay. Yeah. So essentially, the paparazzi is an artist, all right? Is an artist in the sense of the Copyright Act. Because he's a photographer, he used certain skills and methods to took the picture itself. So therefore, he's the copyright owner of that particular picture. Then the celebrity will ask, how is it fair? It is my face is being taken, all right? So why when I upload the picture of my own face taken by you, I'll be sued in court? Unfortunately, this relates to the law of privacy. It is very unfortunate that currently in laws around Malaysia and laws in several jurisdictions as well, the laws towards privacy are not strong enough to protect you from ensuring that your face or your picture not being taken in the public. So the justification or the rationale is that once you walk around in the public, you somehow have consented to your pictures being taken when you are in the public. So it's very unfortunate right now that privacy laws are currently not strong in Malaysia, and yeah, that is the legal position.
Okay. All right. So next one. It says that selling NFT needs license, like DAX license. Does this mean a marketplace needs the same license like Luno?
Yeah, definitely you will. If you're using marketplaces that are regulated in Malaysia, you definitely need to ensure you don't need the license because you're using marketplaces. But these marketplaces, they need to have license if they are selling and trading NFT as a platform in Malaysia. So as an individual user itself, that is fine. But the fallback is always this. Because it is not regulated by SC in Malaysia for NFT itself, okay, if you have any complaint, you have any aggrieved here, you have suffered anything here, you can't go to FD to lodge a complaint because no one governs these marketplaces at this moment. So that is the risk that buyers have to take themselves, and you have to understand yourself.
Okay. Is typing in direct messages enough to prove a transfer of copyright ownership, or will a proper black and white document be needed?
Okay. Yeah. So I'll answer that. How do you prove your copyright ownership? Copyright Act clearly states that any deed of assignment, any copyright ownership must be in writing. Okay. So what does it mean? Most of the time, lawyers would suggest you to get a proper deed of assignment done up. Right? Get it done up. Get it stamped by the LHDN, by the LHDN office, stamp office, and it is a proper document that proves the copyright ownership. So if it's only in direct messages, and that sometimes you may have some problems in proving that in court, because the court has then need to take into consideration all the surrounding circumstances. So say for example, you have texted 1,000 messages, all right? Only the last 200 talks about only the last 200 messages talks about the transferring of the copyright ownership. However, the first 800 messages talks about you do not want to transfer the copyright ownership. So there's a conflicting position and a conflicting issue right there that makes your copyright claim unclear. So to avoid all this trouble, it is always advisable, get a copyright agreement, get a deed of assignment agreement, get a proper sale agreement done up. It's better that way.
Okay. What about photo manipulation? Is that also can consider? copyright ownership. Can you explain it?
Can I believe that this photo manipulation, you talk about, do you talk about the like Photoshop artists that try and manipulate the pictures and so on, or you're talking about the app that automatically manipulates your photos and so on?
Maybe you can explain both.
Yeah,
Because
no problem. I'll go with it. So for the Photoshop artist, right? So essentially, a Photoshop artist also uses sufficient work, sufficient expertise, sufficient effort to create the particular photo itself. Okay, by using Photoshop skills or any other photo editing skills, the Photoshop artist can actually own the copyright towards that particular picture itself. Okay, so I think that part is clear. As long as you spend sufficient effort to create the work itself. Okay. Secondly, we talk about the apps. Okay, those apps that they usually take your picture and modify it, make you to someone else, or make add other features on your faces and so on. Okay, this will depend on the terms of use already in terms of the apps itself. So most of the time, these terms of use are sometimes quite unfair. Okay, that they may own the copyright of all these pictures again, because they are the one they're creating using the apps to create all these pictures itself. So they are the ones that have to own the copyright themselves. Depends on terms of use. It's very unfair, but you're using their app. So yeah, sometimes that's the catch situation.
So basically, if we want to use any filter from apps, we have to read their terms and condition lah to know
Yeah,
whether.
but I know, it's a very taxing thing to go and read every single app's terms of use and terms of condition itself. But there's also on this point itself, I would like to slightly elaborate a little bit more further. Although we understand that copyright laws may be stringent, after the presentation, after the Q&A, you may see that actually I can easily infringe someone's copyright and all those things. However, if we take a step back, if we do not look at it on a pure legal standpoint, if we look at it from a commercial standpoint itself, actually there are lesser copyright infringement lawsuits being bring about on all this. I think the simple rationale is that artists are happy that people are actually sharing their work out there. So there's no point in suing everyone that is sharing your work, because that will not build your fan base, that will not build up the credibility, and that will not build up a good name or reputation for yourself. So legal standpoint, it may be from this angle, but if we take a step back and look at it in the wider sense, it doesn't make sense to sue everyone that copies your work and so on. If it's not for commercial use. So I think that is probably the reason why. Mhm.
Okay, so I think this is the last question.
Right.
I see someone selling Nike shoes illustration and state it as nominative fair use under the trademark law. What does that mean?
Yeah. This. Yeah. Sorry. Farid, you finish first.
That's the question. I see
Oh, okay.
I see someone selling Nike shoes illustration and state it as nominative fair use under the trademark law. What does that mean?
Okay. Yeah, this is a very interesting question, because this crosses between two acts and two areas of law. One is a trademark law, another one is a copyright act, copyright laws itself. So we examine the trademark law first. Essentially, a trademark owner has a right to use the trademark anywhere, and anyone that misuses the trademark, it is a trademark infringement. Okay, trademark owners can sue for trademark infringement. However, we examine the copyright laws itself. So one of the defenses to copyright work is the incidental use, all right, of a work, of a trademark or anything else, or something else, or some other people's IP rights in a artistic work itself. So in this situation, even if it's an incidental inclusion, there may be protection of a copyright over this particular artwork itself, because in essence, the artist still spend time and effort. It is an original work, and it has a sufficient effort and time has been expended to create this particular artwork itself. So there's no clear answer to this. This can only be tested out in the court of law depending on the facts of the case itself. Yeah, I'm sorry, I'm unable to give you a direct answer, because this includes a overlap between two pieces of law. So there's no direct answer to this. So I'm sorry for that.
Okay, thank you.
Yeah.
Do you guys have any more questions you want to ask Mr. Lim? Let me check in the comment section. All right. Okay, I think that's all for today.
All right.
So, I just wanna ask like, if like let's say like people wants to consult with you, like, yeah, how much is your charge? No lah. So like,
Okay, do.
I mean like, is this consider like you're making a live stream like this is like a professional consultation, like what differentiates between this presentation and that like consult with you in like a commercial way lah.
Okay, I understand. Yeah. Okay. So that's all for the question, right? Yeah. Okay. So I can tell you for sure that this particular presentation itself are merely the basics of copyright law and a little bit of trademark law and also a bit of cryptocurrency law as well. So I believe that if you need the more detailed consultation with my firm or with myself, it will be a more in-depth and detailed discussion, particularly catered and tailored towards the facts of your case. Because in essence, in court of Malaysia, in every legal situation, it always depends on the facts. So it is how this the legal structure in Malaysia works. It is dependent on the fact. So sometimes your case may look like a bad case, but after certain studying, after certain discovery of your case may turn out to be not too bad case, and in fact, it can be a good case as well. So that is the difference that between this presentation, which is a very basic and educational, informative presentation that I'm making, compared to another consultation, which is a more tailored, is particular towards your problems and particular towards your issues to how to resolve your issues themselves. Yeah.
All right, thank you.
Yeah.
And then people asking where can they follow you?
Oh, okay. My public profile is at LinkedIn. Okay, so that is my public profile. However, if you want to follow my firm, you can follow us on Ming and Partners at Facebook, Ming and Partners at LinkedIn, or Ming Partners at Instagram.
All right.
Wait a minute. Should I just screenshot the last page of my presentation?
Maybe you can share with me, and then I will write in the comment section later.
Yeah, maybe I can.
Okay, I think we can wrap up this talk today. Thank you very much, Lim, and then for your insights. We already talked so many interesting topics today about copyright, especially in the blockchain and NFT world. And then first, me from Malaysia NFT, CAWA Malaysia NFXT, we would like to thank you so much for taking your time to spend the time with us. Thank you very much.
Yeah, I would like to thank Moon. I'd like to thank Faris, thank Leila, thank everyone from the CAWA team as well. Thank you so much for inviting. It is my pleasure, in fact, to be here. I enjoying it my Sunday afternoon sharing information because this is a topic and area of my interest. Thank you so much. Thank you. Okay, goodbye everyone. Stay safe, everyone.